Martian Man TV, y'all welcome in. YSL Young Thug trial, showing y'all live footage. It's a lot of chaos and limbo going on with the YSL trial. We got more things preventing us from getting the trial out the way because I've been ready for them to free Thug. My personal opinion, along with a lot of my subscribers, is that they don't got enough evidence to, convict Jeffrey Williams, aka Young Thug, of these YSL Young Slime Life crimes or alleged crimes involving Young Thug. They done brought up Rich Homie Quan. They done brought up Birdman and Cash Money. Like, they done threw everybody into it. So, the judge that we got right here, the black judge, we at the point now where they trying to kick him off the case, saying that he had a secret meeting with witnesses, and we got YSL Woody testimony. He's so hilarious and funny. He keep pleading the Fifth Amendment, and he protecting himself a lot. I like that about him. He don't really trust the system as far as the limitations, the legal limitations, of the statute of limitations, as far as how much can I say or how much can I reveal, and y'all twist it up and lock me up for it. We got a situation like that right now with the Tupac situation and Keefe D. Keefe D was comfortable speaking up on a lot of stuff that he spoke up on these interviews, because he felt like, he beat the game. He was real comfortable talking about that night in Vegas with him and his nephew and what took place, because he made a deal with the feds. But as we are seeing, they trying to incarcerate him. So, YSL Woody, he ain't no fool. He paying attention. He feel like he don't want to say too much. You know what I mean? He don't want to re-incriminate himself back into another case based off his testimony, which I feel like is very smart. So I'm going to let y'all hear a little bit of what's going on, and then we're going to come back.
On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Kayla Bumpus, attorney or ABA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were Attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with Attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that we held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had
So, y'all, I fast forwarded a little bit because the judge basically was just rambling about the same things as far as this everybody, presenting a motion or their evidence moving forward, or moving forward to the next date.
In holding Mr. Steele in contempt. As I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in the pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who was there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is the United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, Presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations the trial judge may find an ex parte conference necessary. Cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree at the First Circuit that an ex parte conference is appropriate in that situation. They see C. United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threat.
So y'all, basically, to make a long story short, because I'm seeing the judge, he gonna just keep on focusing primarily on this situation that's going on, y'all. Like, this messing up the whole flow of the case. We've been waiting too long. Trial this, trial being held up for this, trial being stalled for this. So I'm getting tired of all the hold-ups. So it's to the point now they want to move it from out of Funk County. You know, we had a couple YSL members stabbed in there. All while Thug, you know what I mean, on trial. All while all this going on. So it's like it's a bad vibe with the whole Atlanta, Georgia energy right now with this whole trial. So now, because of this whole conflict of interest with the immunity thing with the witness, basically this alleged secret meeting that took place, it's kind of railroaded the whole case up to this point. We supposed to be focusing on the facts and evidence and why y'all got this man sitting in prison for so long. Instead, we focusing on corrupt judges and corrupt attorneys and false witnesses and witnesses being lied to about having immunity and don't really got immunity. You know what I mean? They basically, this is a railroad show. So that's why the judge just mentioned he filing everybody. He gotta play the process game. He gotta follow policy himself. And y'all, this is not good so far. They got too many distractions going on, and all we trying to do is figure out, well, we already know that y'all home Thug for nothing. So everybody who feel like they should free Young Thug, hit that subscribe button. Everybody who feel like Young Thug free and he just been sitting up for nothing, hit the like button. Anybody who rocking with Young Thug and you new to my channel and you rocking with me, hit the subscribe and the like button. Leave some comments. Tell me how y'all feel up to this point. And So now they finna take the judge that we got and replace him with a whole nother one. We got a whole nother conflict of interest going on the defense side. So I don't know if it's Mr. Steele. I don't know if it's directly him, but it's a lot of confusion with this. I appreciate y'all for being educated with me and rocking with Martian Man TV. Much love and blessings to everybody. And I'll be back. I'm gonna keep this video short, but I'll be back to update y'all on what's going on with the YSL Young Thug Rico trial. In the meantime, between time, free Thug.